let's say that we're an individual person even, let's say it wasn't a class, and goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit? Or does it say, no, we can continue to apply the rule as to everybody else in the Second Circuit?
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are exceptions to that.
Yes, that is generally your practice, and I'm asking whether it would be your practice in this case.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Yeah, so that means it's not even the normal time it takes for everything to get up, through the circuit courts and to the Supreme Court, because even in those circuits that say that the EO is illegal, you're going to be saying, no, we only commit to saying it's illegal to this one guy who brought the suit.
Article 3 and the court's traditional equitable practices provide a range of tools to address that, including a potentially nationwide class action. A nationwide
class action, which you say you're going to oppose when that gets challenged.
We are likely to oppose
when
on
that
the merits.
Proposed.
Yes, and if it does not meet the rigorous criteria of class certification, the court should not enter that injunctive relief. That's
do you think,
feature, not a bug.
How about you're not willing to commit to abiding by the Second Circuit's precedent suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought the suit?
No, that would be a nationwide precedent that the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that?
Yes, and in addition, we may well respect circuit-wide precedent. The Second Circuit, it just is.
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
And in the meantime, any of those plaintiffs could have come forward and sought, preliminary injunctive relief, and they could do so on a class-wide basis. There are tools to address this, but the universal injunction, which is issued here 3 days after the executive order was issued, is not one of those tools.